Terrific. Thank you, Jen. Good afternoon, and thank you all for joining us for our webinar today, the Secure Act and Beyond, what it means for your nonprofit and your donors. My name is Nathan Stelter. I'm the president here at the Stelter Company, and happy to be here today to introduce our presenters. Before I get to our discussion for today, I did want to say a couple quick words about the webinar series. I know many of you are familiar with Stelter's webinar series that we host every year. This is a complimentary webinar series. We could no doubt, especially for the lineup of speakers we have this year today included, charge for this, but our belief is as the tide rises, so do all boats in the harbor. So we are very happy you're here with us today. We've got just almost 600 of our closest friends and colleagues on the call today. Today's webinar is actually our first of our 2020 curriculum. Our lineup for this year actually includes a terrific group of speakers and topics, including a walkthrough of the new Giving USA's latest legacy report. We'll also have a discussion around not one, but two successful legacy challenges with our friends from George Washington University. Pamela Davidson, who many of you know, will give us some tips and cues and clues on what your prospects are telling you and what you need to say. Catherine Myrie is going to join us to teach you how to design the perfect marketing strategy for your gift planning program. And the infamous Dr. Russell James will also be joining us this year to share his most recent observations around baby boomers. We have a lot of other speakers and content available as well. To see that, to register and see what the lineup looks like for this year, please don't hesitate to go to stelter.com/webinars, and you can sign up ahead of time for those right now. But as always, we'll be sending out an invite as those events draw closer. So for today's talk, and back to our presentation, I have the privilege to now introduce just one, but two terrific presenters. I'll start with our own Lynne Bomber, who's Stelter's Senior Gift Planning Consultant. Lynne has been with us for 9 years, almost a decade, hard to believe, joining us back in December of 2011. She works with and assists all of Stelter's clients around technical questions related to plan giving, and works closely with our editorial team around content for our clients as well. She's also the author, as many of our clients have probably seen, of Stelter's client publication, Expert Insights, where she shares quarterly a variety of ideas and tips and tricks around the technical side of the world. If you are following Stelter's Insight blogs, you will from time to time see her post there as well. She's a past president and board member of our local Mid-Iowa Plan Giving Council and a member of the National Association of Charitable Gift Planners Leadership Institute. So excited to have Lynne with us today. And also, Larry Katzenstein is a partner at Thompson Coburn LLP, a lawyer that in private practice represents many plan giving programs. You've likely heard him on our series before, as he's a nationally known authority on estate planning and plan giving, and a frequent speaker around the country. In fact, Lawrence is the creator of Table's actuarial software, which is widely used by tax lawyers and accountants. And he and Lynne were terrific in building out Stelter's highly popular Gift Illustrator tool. They work closely on that tool that I know many of you are enjoying. So enough of me talking. I know we've got a lot of content to share and no doubt a lot of questions. I will hand it off to Lynne and Lawrence.
Thanks, Nathan. Thanks, Jen. I appreciate it. And thank you to all of you who are joining us today. We are going to be talking about the Secure Act. The Secure Act is actually 125 pages long, but we're not going to go into every detail for you today. We're just going to hit some of the highlights that as it relates to donors and your organizations. So you've probably heard there's probably three main areas that really are impacting charitable gift planning, and we're going to highlight those and then go into those into a little bit more detail. Then I'm going to go on to my top gifts to make in 2020 as we start the new year and a new decade here, and then some best practices for talking to your donors, not only about the Secure Act, but in other areas as well. Then we'll wrap it up with summary and next steps, and then hopefully have time for a few questions. So I'm going to go turn it over to Larry right away, and he's going to start with some of the main provisions as it relates to nonprofits and your donors of the Secure Act. Larry?
Good. Well, a little history. As you know, Congress gave us a little year-end surprise and ruined all of our Christmas vacations by having a law which was signed into effect on December 20, with provisions taking effect January 1. So over Christmas, we were all reading the new legislation. It is, as your materials say, the most significant retirement plan legislation really since the Pension Protection Act of 2006. There are three main changes that relate to charitable giving. And of course, there's a lot more in the Act that doesn't relate to charity specifically, but has serious implications for charitable giving. The first main change that does affect charitable giving is the fact that it removes the age restrictions on IRA contributions. So that's more discussed on the following slides, but that's the first big change. The second thing it did was change the age for required minimum distributions, and then it also eliminated the Stretch IRA for non-spousal beneficiaries. And if you could go back to where it says no age restriction, okay, you're back there on the slide. So let's look at the first one, which is no age restrictions on IRA contributions. Under the old law, once an individual reached age 70 and a half, the person could no longer make a contribution to a retirement plan. And incidentally, I should say at this point, what we're talking about is IRAs and all retirement plans except defined benefit plans. So 401k plans, 403b plans are all affected by these rules. And the old rule was once you were 70 and a half, you could not make a contribution to an IRA. Under the new law, you can if you're over 70 and a half. If you want to make a deductible contribution, then you can do it if you have taxable compensation. You still have to have compensation to do it, and the dollar limits are not very high. They're the lesser of $6,000 if you're under 50, $7,000 if you're 50 or over, or of course limited by taxable contribution, and it can be made at any time during the year. And for the first time, individuals at any age can now make an IRA contribution. There are no age restrictions now on those IRA contributions, and if you look at the slide in front of you, it talks about what that means for donors and nonprofits. And what it means is that donors have another way to reduce their income with a very small deduction. It means they'll have more in their retirement plans to grow because it can grow tax-free, and eventually, hopefully, part of it will be available for charitable gifts. I think in the long run, this is probably not a big deal because the limits are so low at $6,000 or $7,000 a year. I think it's helpful, but it's not going to be something that moves the needle for most charities or most donors. And the real benefit is that these plan accounts may be larger someday. So I think there's some marketing ideas that come from that. Lynn?
Yes, thank you, Larry. So when you are incorporating into your marketing materials and talking about retirement plans, think about promoting the fact that you want to be not only a death beneficiary, but a percentage death beneficiary. Because as these accounts, as people maybe contribute to them, as they have longer time to grow, those assets will grow over time. And if you give a certain dollar amount, of course, that's a fixed amount. But if you encourage your donors to give a percentage, you could very well end up with a larger amount in the end. Larry?
Okay, let's talk next about the required minimum distributions. Those are also different. And what's changed here is that the age at which an individual must start taking required minimum distributions has been increased from 70 and a half to 72. And that really means April 15, start after the year you become 72. That only affects individuals who were born July 1, 1949 or later. And if an individual turns 70 and a half after January 1, 2020, they must begin taking RMDs at age 72 to avoid penalty. And those penalties are substantial. It's basically a 50% penalty. So it's important to make sure that those withdrawals get made. And custodians usually are pretty good about warning people about that. So the age has been increased when you have to start making RMDs from 70 and a half to 72. And that's really a reflection of the longer mortality, longer life expectancies that individuals have now. What that means for nonprofits and donors is that there is now an extra year and a half for those retirement plans hopefully to grow and in a tax-free environment. And that may very well result in larger account balances, which hopefully will be available for nonprofits and charities to have to be named as the death beneficiary for a portion of those accounts. And so it could result in larger charitable contributions. There'll be another year and a half for the funds to increase. Now, this may cause some confusion because they did not change the minimum age for contributions. You can still make contributions at 70 and a half for the first time, I should say, but you don't have to make withdrawals until later now under the new law. So those two things are different. And you can still do a qualified rollover at 70 and a half, as we'll see, even though you're not required to make distributions until a year and a half after that under the new law.
So that gives you some more marketing opportunities for you. I mentioned the death beneficiary percentage designation earlier, but what about QCDs, qualified charitable distributions, also known as the IRA charitable rollover to many of your donors still. So make sure that you, when you are looking at your current materials, make sure that you are reviewing them and noting that the QCDs do still start at 70 and a half, but yet RMDs will not start until 72. So I know there's been confusion already among donors, even among development officers, of what ages begin at what times. And I know sometimes when you look at those materials, you see 70 and a half and then you see 72. So just make sure that you are talking with your donors about the different ages and what's available to them. They may think that QCDs are now only available at 72, which is not the case. So you just want to make sure that your marketing materials are still promoting the fact that qualified charitable distributions are still available at 70 and a half.
Yeah, and I might add that for someone who is 70 and a half but not 72, probably the better strategy is to make their charitable contributions from other assets and get a tax deduction, and then let the fund grow tax-free a little bit longer, and then wait until they have to start making their required distributions at that point to start doing their charitable rollovers. The distribution rules made one other change, which is the elimination of the Stretch IRA for most non-spousal beneficiaries. As I'm sure you all know, a payment at death to a family member who is not a spouse could then, in most cases, be taken over the lifetime of the individual. So I could make my child the beneficiary at death of my IRA, and that child could establish an IRA of his own and take distributions over lifetime. That had been criticized for years because the whole purpose of these plans was to provide income for retirement, and there was less justification for doing it for a family member who was a child, for example. So this did get changed, and it raises a lot of revenue as well, which of course influences Congress. And so under the new law, the Stretch is only available in most cases for a spouse and for a few other individuals we'll talk about in a moment. And again, this applies to any of these retirement plans we've talked about before, other than defined benefit plans. And so the new law is that if I make a death beneficiary designation to a child, for example, the child must take out the entire account balance by the end of 10 years. Now, there's been a little confusion about that in the sense that the 10 years rule means that by the end of the 10 years, all of the funds have to be distributed. They do not have to be distributed over 10 years. So you can wait until the end of the 10th year and make the withdrawal at that point. But at that point, they all have to come out or you face these substantial penalties for failing to withdraw the account balance. This rule applies to accounts inherited from owners who passed away before, I'm sorry, I'm saying that wrong. The RMD rules for accounts inherited from owners who passed away before January 1, before this year, are unchanged. So anyone who died before this year, you're still under the old rules. That can still be taken over lifetime. They didn't undo that. But for anyone who dies this year or after, unless it's a spouse or one of the other excluded beneficiaries, then it has to be taken out over no more than 10 years. Now, in addition to spouses, there are a couple other categories where you don't have to take it over just a 10-year period. And those exceptions are for a child of the employee who had not attained the age of majority, for a disabled beneficiary, for a chronically ill person, and that's defined in the code pretty narrowly. It's got to be a lengthy kind of a condition, and it has to be certified and so forth. And then the fourth exception is for an insured who is not more than 10 years younger than the employee. But other than those kind of limited categories, anyone else other than a spouse must take out the IRA or other retirement plan benefits in no more than 10 years. Let's see. What that means for nonprofits. This is a tax-generating provision, and it may be that Roth IRAs are more attractive now. And some individuals may wish to look at whether it makes sense to convert a traditional IRA to a Roth IRA. What you have to do in that case is incur the tax now, but then it will grow tax-free after that, and it will grow tax-free and come out tax-free to the employee in the future. So there may be some benefit, especially now that tax rates are pretty low, to do that now and consider that Roth conversion. This also means there may be increased interest in naming a nonprofit as a death beneficiary, leaving other assets to loved ones. And it may be, as we'll see in a minute, that some of the deferred kind of planned gifts, such as charitable remainder trusts and gift annuities, may be more attractive as a way of stretching out these benefits. And we'll look at that a little later, rather than being stuck with the 10-year payment. Then if you look at some of the other key provisions, which is on the next slide, you'll see that you can still withdraw funds at age 59.5 with no penalty. That has not changed. You still, of course, it's still subject to income tax, but there's no penalty for a premature withdrawal. And if you need to access retirement plans before that, then there is a 10% early withdrawal penalty. The Secure Act added an exception, and it's a small exception, but it does allow up to $5,000 to be withdrawn without penalty from a retirement account within 1 year following the birth or adoption of a child. For married couples, each spouse can draw up to $5,000 from the retirement plan accounts penalty-free. Other key provisions. There is a provision that allows a grad student who is pursuing a graduate or postdoctoral degree or research to treat as compensation the amounts that are paid to those students for purposes of making an IRA contribution. So if I'm getting a taxable stipend as a graduate student, that counts now as compensation so that I can make an IRA contribution. Whether many graduate students will have enough assets from those small stipends to make an IRA contribution is a different question, but for those that can afford it, it's a great way to start saving for retirement, even when the student is just in graduate school. 529 accounts. They, as you know, allow distributions of up to $10,000 for qualified loan principal and or interest payments. That's a helpful change that applies to distributions made after December 31, 2018. And so a distribution could be made to help reduce some of this qualified student loan amount. It allows for a $10,000 lifetime payment, not an annual amount, so it's a small amount that can be used for that, but it's better than nothing. And it does allow distributions to cover certain eligible apprentice costs. That also applies to distributions made after December 31, 2018. And it expands coverage for homeschooling, which was something that was not available before. What about part-time workers? 401k eligibility. We now find that under the law, employees who have worked at least 500 hours for at least 3 consecutive years can participate in a 401k plan. Those reduced eligibility requirements will again help people save for retirement, and hopefully some of those assets will eventually find their way to solve charitable goals. the employee must be 21 by the end of the three-year period, but that's not going to keep too many people from doing this. So, Lynn, do you want to tell us a little bit about the Secure Act and charitable giving?
Thanks, Larry. Yes, I'll go ahead and start here. I'm going to go in and dive a little bit deeper into some of the topics we just discussed and how it impacts nonprofits and donors. So I'm going to start with qualified charitable distributions, and then Larry's going to talk about testamentary life income gifts, which includes charitable gift annuities and testamentary charitable remainder trusts. So let's start with QCDs, or qualified charitable distributions. So again, what Larry said, the age for which one can make a qualified charitable distribution did not change. It is still at 70.5. You can still make, the IRA owner can still make it the gift directly to charity, any amount up to $100,000 per year. And of course, it needs to be a qualifying public charity. So that has not changed. We want to make sure that you understand that. Make sure, so this is just an anecdote, make sure that you're reviewing your QCD letters. And what I mean by that is many of you have sample letters that do have like an IRA request that you send to donors, where the donor can send to their IRA administrator and request a qualified charitable distribution. Make sure you're reviewing those letters. I know that I reviewed one of them, and in that language, it talked about not only making the QCD, but also that it was going to satisfy all or part of the RMD, the requirement distribution, which may or may not be the case now. So make sure that you are reviewing those letters. If you need samples, my last blog available on the Stelter website does have a couple examples, sample letters for you, and you can certainly download those for free. So under the Secure Act, the one provision that has created a lot of, I think, anxiety among development officers is that any QCD will be reduced by the amount of tax deductible contributions to your IRA. And what do I mean by that? So Larry talked about the fact that past 70.5, you can continue to make IRA contributions subject to the limits to your IRA. But there's going to be now a correlation between QCDs made after January 1st of 2020. And I think the best way to explain this is really by an example. So let's take a look at this. So let's just say that we have Jane, who works part-time. She's 72 and she makes a $7,000 contribution to her IRA in 2020. And she'd also like to make a $50,000 qualified charitable distribution to her favorite charity in the same year. Because individuals can now give to their IRAs, and the IRS does not want to have what's called double dipping, they only allow her to make a qualified tax-free charitable distribution in the amount of $43,000. It would be the $50,000 minus the $7,000 contribution. So Larry and I have talked about this. We don't see this being a huge issue, but it is an issue that I think you need to be aware of, especially if donors come forward on this. And many instances, you may not even know about it. You may know about the qualified charitable distribution to your organization, but you may not know about any additional IRA contributions that the donor has made unless they tell you. Let's take another example just to make sure that we are understanding this. So not only is the QCD reduced in a single year, but let's say that Jane here continues to work part-time and continues to save for her retirement and make contributions. And she's making annual contributions of $5,000, and she does that for 3 years. But in the end of the third year, she wants to make a $50,000 qualified charitable distribution. So those $5,000 annual contributions add up to $15,000 over 3 years. So she's only allowed to make a tax-free qualified charitable distribution actually of $35,000 on her tax return. So she can make the $50,000 gift, but it's really going to be only tax-free for $35,000. So this particular provision, I know, has been creating a lot of, I think, anxiety among development officers. I see a lot of comments on the CGP link and of trying to figure all of that out. What was interesting to me is I was talking with one of our clients, and they were saying, well, how would I know? How would I know whether a contribution was made? And many times you won't. And then she said, well, do we need to, what about our letters, our acknowledgement letters, when we get a gift from a qualified from an IRA? How does that work? And really you don't necessarily reference the fact that they made a contribution. That's for the taxpayer, and that's for the taxpayer's financial advisors or CPAs, and that. So just be mindful of this, and so that you can educate your donors on the basics, and of course always refer them to their financial advisor for additional questions on how it will impact their unique situation.
Yeah, I might add a couple of footnotes to that as well. What charities probably should do when they get rollovers from now on is not say that it was a qualified rollover, just acknowledge that you received a distribution from the IRA. And this will create some really interesting compliance issues. If I only have one IRA, then the IRA custodian can correctly report to me how much of my rollover qualified and how much didn't. But if I have two IRAs with different custodians, they're not going to know what each other does. And so the 1099 that they give to us, the 1099-R, showing the amount that is a rollover that's qualified and the amount that isn't, they're not going to have the correct numbers if you have more than one IRA and you've done rollovers from several. So I think the IRS is going to be faced with some interesting compliance issues here, and it'll be confusing for donors, I think, for a while until this gets straightened out. The one question we got before the program was exactly that. If the QCD is reduced by the amount of the contribution, does that change how the profit acknowledges the gift? And again, I think you just referenced the amount received without saying it's a qualified or rollover.
Yeah. And we just got a question just from the group, Larry, that, is it only limited to 3 back years? What happens if she contributed 5 years? Well, it doesn't matter. There's no limit on the years. So if Jane, in our example, had contributed 5 years, all 5 years would be counted
Yep.
and towards that. So it's not just a limit to 3 years. That was just an example.
Yep.
So thank you for that question, Ellen and Evan. Just moving ahead, and this is actually a question that's already coming up on the board here, that how can we encourage donors who are in that 70.5 to 72 to make a distribution from their qualified, from their IRAs? And so what we want to make sure is that, one, your messaging talks about the RMD and 72, but you really want to make sure that you've got special messaging on this age group to motivate them. So what can you do? Gift allows them to make a difference today. Obviously, if they give directly from their IRA, and they can see the impact that they're making today at all of your organizations and many times their own communities. You're making a gift from the most highly taxed assets, right? So when these assets are eventually distributed to loved ones, they are going to be taxed at the beneficiary's ordinary income tax rate. So make these gifts from the highly taxed assets, and then maybe give other assets to loved ones. It's not going to impact current spending. So, when you're talking about like weekly budgets and things like that, they can certainly just make a gift from their QCD without incurring income. And, the markets are really high right now. And so many of those account balances are higher. And so, make it now to maybe hedge off eventual market decline. We'll have to see about that, but it's a good time. So just remember that messaging to continue to motivate your donors who are in that 70.5 to 72 age group. Larry, I'm going to turn it back over to you.
Okay. Well, one of the things that has engendered a lot of discussion is the fact that we no longer have the lifetime stretch for most beneficiaries. And so people have looked at other ways to get a stretch through planned giving vehicles such as the Charitable Remainder Trust. As we saw before under the new retirement plan rules, distributions have to be made except for a spouse or for certain other limited categories by the end of the 10-year period. You can't go for lifetime with a child as we used to be able to. The 10-year rule works like the old 5-year rule did, which means basically, as I said before, you have to take it out by the end of the period. You don't have to take it out over the 10-year period. So one thing that can be done perhaps is consider a distribution to a charitable remainder trust for a child, either for the child's life or for a term of years that would last for the child's lifetime and therefore enable the funds to be distributed over a lifetime. They will come in and not be taxed in the trust. The charitable remainder trust, of course, is tax exempt. That will be Tier 1 income, ordinary income, and when it comes out, it will be taxable, but it will be spread over a much longer period and be able to grow tax-free inside the charitable remainder trust over a lifetime rather than just for 10 years. So this will make a lot of sense for donors with substantial retirement plan accounts who have younger beneficiaries that they don't want to have receive the entire amount outright, or over 10 years they want to stretch it out for a longer period, sometimes for tax reasons, sometimes for non-tax reasons, either concerns about creditors or how responsible the child is. Lots of good reasons that we use trusts. The one thing that I think we always have to keep in mind about this technique or any other is the donor has to have charitable interest to do this. So if you have $1 million going into a charitable remainder trust with a 5% payout and it pays 5% a year, at the end of the child's life, there will still be $1 million there. And this really only makes sense, obviously, as with all of these vehicles, for donors who have charitable interests. For those that do, and also want to do something for family members that enables them to get a stretch, I think this will be a very popular technique and has a lot to recommend it. So let's talk next about charitable gift annuities. And here there's some really interesting issues. What you would do to create a testamentary charitable gift annuity agreement is in the retirement plan death beneficiary designation, you would provide that the payments would be made to a charity as the purchase price for a charitable gift annuity. It's important that the beneficiary designation be very specific about exactly what is to be done. For example, you have to specify what the annuity rate will be, and the easiest way to do that is just incorporate by reference the American Council on Gift Annuity Rates that are in effect at the death of the individual. And you can also instead say whatever rates the charity is issuing at that moment, because some charities do issue rates that are not ACGA rates. You have to specify whether the payments are made quarterly or annually or some other period, whether they're made at the beginning or the end of each quarter, if it's quarterly or a different period. You have to be very specific so that it's ascertainable as of moment of death, so you don't jeopardize any deductions, state tax deductions. It can be done, as you know, with one or two annuitants, as any other gift annuity, and at the end of the annuitant's lifetime, the balance supports the organization. One nice thing about the gift annuity that is different from the remainder trust is that you can do a deferred annuity, and you can do a step annuity that increases gradually over a period. And so those are benefits that are not available with the remainder trust. Now, having said that, let me raise two cautions. One is, I think there's at least a question whether you get an estate tax charitable deduction, because in a way, making a distribution to a charity for a gift annuity is like an offer to purchase. And until it's accepted by the offeree, maybe you don't have a contract. So I think there's at least that issue. Most people don't pay estate tax anymore, so it won't affect those people. The other unanswered question is whether the amount going to the charity for the gift annuity, which is income in respect of the decedent, is still taxable in the hands of the recipient, gives you an investment in the contract. If I buy an annuity with cash during my lifetime, then I can spread my investment and contract over my life expectancy. If it's income in respect of a season that I have zero basis in, it's not 100% clear what the rule is there. There is only one ruling on this, 2002-30018, that discusses this issue and punts on that one question, although they do say the IRD is taxable to the charity. So that's an open question, but it's not going to be different than the remainder trust in the sense that that will all be Tier 1 income in the CRT and also be taxable. So it's not worse than the remainder trust in that respect. Let's go next to charitable remainder trust. If you do a charitable remainder trust, then it could either be done to a trust that's created in a will or an irrevocable trust. It could be a standalone document. It could be an additional contribution to one that's already been set up during lifetime. And it can be for a term of years, which is something you can't do with a gift annuity. And at the end of the person's lifetime, it will go to the charity or charities under the plan. You can even give flexibility to others to broaden charitable purposes and so forth. So there are lots of things you can do with a charitable remainder trust, and in a way that's a more certain vehicle than the gift annuity, although it is less flexible for the reasons we've said. But for donors with charitable interests, I think this really will be a popular technique for donors who would like a longer stretch, often for non-tax reasons, than you would be able to get over the 10-year period. So some tips to discuss with donors are, discuss the increased flexibility with the CRT, the fact that you can do for more than 2 life income beneficiaries. You could do it for 3 children, for example, have it end at the last death. You can have more than 1 charitable remainder beneficiary. So this is a technique we're very familiar with, the charitable remainder trust, and this gives us a new way of funding the trust with an asset that otherwise is going to be distributed over a 10-year period to a child or other family member who's not a spouse, and incur the income tax that goes with that distribution. So as I said, I think this will become a popular technique, again, and I always emphasize this, for donors who have strong charitable interests.
Yeah, I just want to add to that. I was at a discussion with a client just yesterday or earlier this week, and she was talking about individuals who may be interested in a CRT, but maybe not wanting to go through the expense of setting up a charitable remainder trust with an attorney. Obviously, there would be expenses involved with that. So she said, well, can they set up 3 different CGAs, 1 for each child, testamentary CGAs? And the answer is yes. So, you know, that's something that may be a topic of discussion for you as well.
And of course, the attorney's fees that many donors are worried about really can be minimized. What many charities do is provide them with a sample, which the donor then takes to their attorney for review, and then at least it saves some of the cost of preparation. And I think that's a pretty common way of dealing with that issue.
Okay, moving on ahead to the top 5 gifts to make in 2020 as we start the new year and start the new decade. Let's find out what type of gifts you should be talking about and promoting in your marketing materials. Number 1, gifts of appreciated stock. The stock market's at or near all-time highs. So if you want to grow your planned giving program, you really need to be focusing on non-cash assets and appreciated property, whether that's stock or real estate, are certainly going to come in under that. If you are familiar with Russell James, Dr. Russell James, he has a great 1-page synopsis of how to grow your planned giving, and it's called Cash is Not King in Fundraising, Results from 1 Million Nonprofit Tax Returns. And it talks about the planned giving programs that have grown, that have emphasized giving of non-cash assets. So I wanted to just take you back a little bit of when I say stock market is at or near all-time highs, there are lots of gains in the market right now. So let's just go back. So just before I got on, I took a look at what the Dow Jones was doing, and it was hovering around 28,875. If we go back to exactly 5 years, January 29th of 2015, the stock market was at 17,191. And if we go back a full decade to January 29th, 2010, the stock market was at 10,067. So there's a lot of gains here. So if your donor is wanting to make a gift, but maybe not want to impact their current like checkbook giving or current spending, really think about giving gifts of appreciated stock, appreciated property. They can minimize or eliminate their capital gains. Real estate's another one. Many real estate markets are experiencing growth. Number two, not surprised, qualified charitable distributions. This gift, I think, hit the trifecta. When you take a look at the Tax Cuts and Jobs Act and how it nearly doubled the standard deduction, and so many less people are itemizing their deductions. And then you add the Secure Act on top of it, where all these individuals can save a little bit more, and all these assets are accumulating into these retirement plans. And you take into effect all of the aging baby boomers. I honestly think that this is just a great gift to promote, really at any time of the year, but we usually recommend that you promote it at the beginning of the year, at the end of the year, especially if you had to choose a time of year to promote this gift. Great for non-itemizers, doesn't count as income for those 70 and a half and older. And again, you're making a gift from the most highly taxed assets. Just a little bit more information. Chronicle of Philanthropy, May of 2019, 74% average growth in gifts from IRAs in 2018, average donation of $9,200. So really great gift for donors to make in the 70 and a half and older category.
The other thing, as Lynn was saying about people not itemizing much, that is so typical of people over 70 and a half now, because they probably don't have a mortgage anymore. They may very well have only one deduction, which is their state and local income tax, which is capped at $10,000, and their standard deduction may be $26,000 or so. So they will not be itemizing, and with the qualified rollover, they avoid having this amount in their income at all, and so they get the benefit, the same benefit as if they got the distribution and then gave it away and deducted it, except it doesn't go in their income, and they also get the standard deduction. So that is a very typical older donor who is not itemizing, and this is an extremely attractive technique for.
Okay. Number 3 on the list is donor advised funds. Take a look at some of these statistics from Fidelity Charitable's most recent giving report. Over $121 billion in total charitable assets. Contributions to DAFs increased 24% just in a year. Grants to qualified charities, $23.42 billion. So you take a look at this. It's the fastest growing source of philanthropy. I was on a webinar not too long ago. They said that this is now the 3rd most popular gift type behind bequests and beneficiary designations. Donors are using them to bunch gifts when we talk about trying to get over that standard deduction from that Tax Cuts and Jobs Act. So really a great gift vehicle for donors. Donors like them for their simplicity. And I'll admit, nonprofits were a little hesitant to promote these at the beginning because the dollars were going elsewhere. But at the same time, if you're not promoting them, I think you're possibly leaving money on the table. You really need to look into these and talk with your donors, because many of them, of course, have donor advised funds now. So what we're seeing here from a marketing perspective is that some of our clients are taking that deeper dive. they're saying, okay, we've got all these donors who have donor advised funds, and how can we specifically target them? What messaging can we use? And honestly, it's taking a deeper dive. You've got your donor advised fund messaging of what is it and how does it work and how do you create one, and the sponsoring organizations that are available, community foundations and others. But what about those donors who already have that? They don't need that information. Take that deeper dive. Try to segment that donor base if you can, and create some really specific messaging towards that group, of naming your organization as a beneficiary, for example, creating a legacy of giving and recommending recurring gifts. So there's lots of other things that you can take a deeper dive with, and so you may want to consider doing that with your donor advised fund donors. The target market here is very wide-ranging. You've got the average DAF donor is 46 to 64. The balances are not large. 58% of balances under $25,000, and only 8% have more than $250,000. And donors of all histories are giving. So this is a great market. I think it's for that age group, especially 46 to 64, that you can target.
I would also just add that the other benefit the donor advised fund has for our clients often is that it's so much cheaper as an alternative to a private foundation. And I think that for every 10 clients who have come to me over the years and wanted to do a private foundation, I've talked 9 of them into doing a donor advised fund. It's just much less risky as far as all these self-dealing rules, and it's much less expensive to maintain.
Thank you, Larry. Number 4, gifts from retirement plan assets. Again, not surprising now that the Secure Act is going to, I think, allow more time for these accounts to grow. And so really encourage your donors to give via a beneficiary designation, and hopefully a percentage death beneficiary designation. When you are doing this in your marketing materials, please remember to have your donors maybe do a certain call out or pull out section on ways to notify you. Otherwise, you won't know that it's there. And there's a lot of times these organizations, their underlying documents will say that they have no duty to locate beneficiaries. And so you really want to have a pull-out section or a call-out section, or just even in your conversations, to notify you that you've been named as a beneficiary to these assets. And number 5, life income gifts, CGAs and CRTs. This includes inter vivos and testamentary, like we talked about. Testamentary is new. I haven't recommended that before, but given what's happened with the Secure Act, I am recommending that as well. Inter vivos, these are great gifts. Really for the mature and baby boomer generation that are concerned about retirement income. A lot of them are charitable, but yet have those concerns about health care or memory care or what's going to happen down the road. So this way they'll be able to get either a variable income over with a CRT, or a fixed income with a charitable remainder annuity trust or a CGA. So and these are individuals who, may want to stretch that 10-year period back out into a little bit longer for their beneficiaries. Now we're going to go on to the 10 best practices for talking to your donors. So the first and foremost, number 1 and number 2, understand what it is about your organization that is important to your donors. And that involves listening. And it's no surprise that your donors should do the talking and you should be the listener. You need to find out what's important to them, what programs are important to them, whether if you're in education, if it's scholarships or athletics, whether if you're in healthcare, whether that's certain types of diseases, cancer, or other things. So really find out what's important to your donor. And again, listen to your donor about what's important to them. Encourage your donors to meet with their professional advisors. Some of our content will talk about, it's time to look at your estate planning documents when there's maybe a marriage or a birth of a child, but we also recommend when there's tax law changes, which of course just happened 2 years ago for sure, but then there's more retirement plan changes now. So really make sure that they're meeting with their professional advisors. And when they're meeting them, of course, it's a good time to include maybe a beneficiary designation or a bequest in their will to your organization. Number 4, many of your donors, of course, will have larger retirement plan accounts now, not only because of market conditions that I talked about earlier, but their ability to make additional contributions, the extension of RMDs from 70.5 to 72. So consider naming a percentage of their account to your organization. Once again, the stock market is at all-time or near all-time highs, and so have your donors consider a gift of stock to minimize or eliminate capital gains taxes. Larry?
Yeah, another one is that many of our donors are now realizing that they are not able to itemize their deductions because of the $10,000 cap on state and local taxes, and that the standard deduction, which has been greatly increased, is better. So one way that those donors can enable themselves to itemize deductions is by making larger gifts than usual so that they can bunch gifts. In other words, go to the charity, say, I would like to prepay my next 3 years' gifts now, and then they will have enough of a charitable deduction that maybe they can itemize. Another thing that we've talked to our clients about, suppose they have a bequest to charity in their will. Talk to them about prepaying it during lifetime if they can afford to do it, and to get the income tax benefit of the deduction, which makes sense anyway, but it's even better now because it may enable them to itemize when they couldn't before. Another thing to talk to donors about is the fact that with the new limits on how long you could stretch out payments for a non-spousal beneficiary, maybe that payment to a life income gift that you do a death-by-death beneficiary designation through one of these life income options is better. It enables the payments to be stretched out over a term of years or for the lifetime of the individual, which some donors will find very attractive. Another thing to talk to donors about is American Council on Gift Annuity rates. One thing that I always remind our charitable clients about is that these are maximum rates. Donors can also always accept a lesser rate. So if an elderly donor is happy getting 7% instead of 8%, they'll get a larger charitable reduction and it'll help the charity more. So talk to donors about gift annuities. And the main thing, of course, is to talk to donors about the good they're doing for your institution. They're making these gifts because they have a love for what you do as a charity. And so always remember that that's foremost. And the tools are just a way to get there, but they're not the thing that should drive the transaction. It should be the love of the charity and the good things the charity is doing.
And then your final best practice talking point is really asking your donor about their connection, and is there someone important in the donor's life who has maybe influenced them regarding your mission or organization. And that could be a lot of various ways the donor is connected to your organization, whether that's through again, maybe a mother had graduated from the university, or a grandmother had cancer, other things. So really talk about a connection. And our research shows that when it comes to types of planned gifts, donors to all nonprofit sectors prefer honor and tribute gifts by a statistically significant margin. So really make that emotional connection when talking with your donors. So summary and next steps, I always like to give homework. So make sure that, one, you're understanding how the laws impact your organization and donors. So this is a great start. Don't let it stop here. There's lots of information out there on the Secure Act, including, on our website, but there are more opportunities, whether it's through your local Plan Giving Council. The National Association of Charitable Gift Planners Conference is in October in Chicago. But there's, and of course, you know, your colleagues a lot of times are great references. And then go ahead and review those marketing materials. Look for outdated provisions. Look for things that may have slipped through. Review your QCD letters and especially your QCD marketing materials. So we just have very limited time, and I apologize that we did not leave more time to answer your questions, but we will just take a few here, and I do want to say that there are a lot of questions that have come up throughout the presentation. If you want to reach out to one of us, our emails and our phone contact information is on the slide right now. Please feel free to email your questions if we do not get to them during this very limited time here. So one question that I have, which I think is a great question that came through, is what would be the typical advice or strategies from a financial planner advisor to a client that has large amount of money in retirement assets? And I'll start with this, and then Larry can add. But obviously, what we talked about earlier is to make qualified charitable distributions, to make your nonprofit as a percentage death beneficiary. For those, and then let's talk about maybe those who aren't charitable that you may be hearing about. Of course, the conversion to Roth IRAs. But another one, I was talking with one of the members from Mid-Iowa Plan Giving Council yesterday from one of the larger financial organizations, and she said that they're recommending that when you have two spouses, that you give you give 50% to the spouse and 50% to the kids. Let's say, start that 10-year running for the kids, and then maybe the next spouse doesn't die until 10 or 12 years later. Then another 10 years starts up again, right, for the remainder of those assets. So it was kind of an interesting thing that I hadn't thought of, but it's something that they're recommending. Larry, do you have anything to add about that?
Well, the other thing to think about is for someone who is giving more than they can do with an IRA rollover is to simply make large charitable contributions from what they get out of their IRA. It'll be deductible. It may be enough to make them allow them to deduct other gifts. So the fact that they will have large distributions gives them more funds to be able to use for their charitable gifts in addition to what they can roll over. And it may allow them to now itemize. So don't think that you're limited to $100,000 in using proceeds from an IRA, in other words.
Yeah. A couple other questions, and I'll kind of lump them in. They've come in under this 10-year rule, Larry. And you can take out the 10-year. So in the event you have a beneficiary who it comes under the 10 years, they can elect not to take any distributions until maybe year 8, 9, and 10 when they're retired, correct?
Yep. Yes. It has to be taken out by the end of the 10th year. It does not have to be taken out over 10 years. Yep. That's exactly right.
Let's see.
I'll answer one more question that I've had, which goes back to the effect of the contributions which are deductible to an IRA. I think some people misunderstood the statute. When it does not actually reduce the $100,000 as such. It reduces the amount you can deduct. So, for example, if I have a $6,000 well, let's find a different number. Let's say I do a $10,000 gift, and it reduces my amount that I can do in the rollover by my deduction, but it reduces the amount of my exclusion. It doesn't reduce the $10,000 as such. It reduces the amount that is excludable from the charitable rollover. I think that's been misunderstood a lot.
Okay. Thank you, Larry. And again, I just want to wrap it up here before Jen gets back on. We are out of time. Again, please make sure you reach out to us. Again, our contact information is on there. I'm sorry we didn't get to all of the questions. Please continue to do all the great things that you are doing for our communities. It's certainly great that you do this each and every day. I'm going to now turn this over to Jen for her to wrap up.
Yeah, thanks, Lynn, and thanks, Larry, so much for spending the last hour with our group of colleagues here. We had about 600 people on the call. Thanks so much for spending your lunch hour with us. As Lynn said, both her and Larry are willing to answer your questions. You can reach out to them. Their emails are on the screen along with their phone numbers. And just one more slide with that, so you can jot those down if you didn't have a chance. If you have questions about our webinar series or Stelter's services or products, you can email myself or Stella at stelter.com, or you can visit us at stelter.com. Finally, we did record the webinar today, and we will be making the webinar recording available along with the presentation slides and some sample language, some sample testamentary CGA language. These will all be made available on our website at stelter.com/webinars. Look for those to be in place by Monday. So you can head there Monday and you'll be able to get the recording, the slides, and some sample testamentary CGA language. So that's all we have for today. Thank you again for joining us, spending your time with us, and make sure you head to stelter.com to sign up for the rest of our curriculum of webinars for 2020. Hope to see you next month. Thanks, everyone. Bye-bye.